Be ready. 5 seconds.
During the course of the search and seizure proceedings, numerous documents and digital devices belonging to the appellant, the company and other employees of the company were seized. Stop. The appellant was arrested in connection with the said FIR. Stop. It is relevant to mention here that the said arrest memo is in a computerized format and does not contain any column regarding the single quote grounds of arrest quote close of the appellant. Stop. This very issue is primarily the bone of contention between the parties to the appeal. Stop para. The proceedings of remand have been seriously criticized as being manipulated by learned senior counsel for the appellant, and aspersions of subsequent insertions in the remand order have been made. Stop. Hence, it would be apposite to reproduce the remand order in pictorial form so as to form a part of this judgment. Stop. The appellant promptly questioned his arrest and the police custody remand granted by the learned remand judge by preferring criminal miscellaneous case number 7278 of 2023 in the High Court of Delhi, which stands rejected by the learned single judge of the High Court of Delhi. Stop. The said order is subjected to challenge in this appeal by special leave. Stop para. Learned senior counsel representing the appellant canvassed the following submissions in order to question the proceedings of arrest and remand of the appellant. Colon para. That the FIR in connection of which appellant was arrested is virtually nothing but a second FIR on same facts because prior thereto, another FIR had been registered alleging violation of foreign direct investment regulations and other laws of the country by the appellant and the company, thereby causing loss to the exchequer. Stop. A copy of the said FIR was, however, not provided to the appellant. Stop. By treating the FIR as disclosing predicate offences, the Directorate of Enforcement registered an enforcement case information report for the offences punishable under sections 3 and 4 of the Prevention of Money Laundering Act, 2002. Stop. The ED carried out extensive search and seizure operations at various places, including the office of the company NewsClick Studio Private Limited, of which the appellant is the director. Stop para. Per contra, learned ASG, appearing for the respondent vehemently and fervently opposed the submissions advanced by the learned counsel for the appellant and made the following pertinent submissions. Colon para. The right conferred upon the appellant by Article 22(1) of the Constitution of India to consult and to be defended by a legal practitioner was complied with in letter and spirit because the relative of the appellant was informed before producing the appellant before the learned remand judge. Stop para. He urged that the advocate transmitted a written objection against the prayer for police custody remand over WhatsApp through the head constable, and the learned remand judge has taken note of the said objection opposing remand in the remand order, and thus it would be futile to argue that the order granting remand is illegal in any manner. Stop para. Though we would have been persuaded to direct the release of the appellant without requiring him to furnish bonds or security, but since the charge sheet has been filed, we feel it appropriate to direct that the appellant shall be released from custody on furnishing bail and bonds to the satisfaction of the trial court. Stop. We make it abundantly clear that none of the observations made above shall be treated as a comment on the merits of the case. Stop.